my lady, just two more points on the treaty. The first is the Article 5 point my learned friend made. Article 5 is on the screen, SB 22.4. This was the point made for the first time yesterday about Article 5D and the reference to proceeds arising from the sale of the investment. I believe the suggestion was that this shows there must have been jurisdiction even after parting with the investment. Now, the premise of my learned friend's argument is that the proceeds would themselves not be a protected investment. And in my submission, that is wrong. What we see operating this provision is a change in form of the investment. Now, it's not contentious that an investment that changes form can still be protected as an investment after that change in form. Indeed, the judge below confirmed as much in part of one of the judgments that the court may not have looked at closely. It's the August judgment, please, operator, at CB 23, page 37. Now, while it comes up, my lords, my lady, this point was in the context of a debate about whether an arbitration award could be viewed as a continuation of a previous investment. And I should note, largely for the future, that there may be particular aspects to that debate that the parties will need to get into. But the general principle that an investment can change its form and that the new assets resulting from that change in form have treaty protection as an investment is well established. If we can go now to paragraph 139.
Couldn't you have under Article 5 the free transfer of the ... and I think we've been given either returns or payments. Couldn't you have the free transfer of the returns, namely the proceeds of sale, to a third party being requested?
That may well be requested, but the point taken against me, my lord, I think is slightly different, which is that a claimant, an investor, would sell the investment and then have the proceeds. And that is an indication in the treaty that there should be jurisdiction thereafter, whereas the Czech Republic's position is that there is no jurisdiction. Against that point, my lord, what I'm suggesting is it doesn't take the defendants any further, because what we are dealing with here is a change in form of the investment, so that you would still have those proceeds, which can then be regarded as a continuation or a change in form of that previous investment. And that's why I'm pointing to his lordship's judgment below at paragraph 139, because that general principle about change in form has already arisen in this case and has already been adopted by his lordship, indeed at the submission of my learned friends.
Yeah, what I had in mind was that the investor sells the investment and assigns the proceeds to a third party or to his bank, for example, and says pay my bank or pay my friend.
Yes.
And the state doesn't, and so he needs to bring a claim against them under the treaty for not doing that, although he himself has divested himself of the proceeds.
Yes.
No jurisdiction?
I would need to think about that, my lord, because assignment of interests and claims of that kind may give rise to particular circumstances. What would certainly not change in my submission is that breaches alleged after the alienation of the investment, in whatever form it takes, the original or the changed form, those would fall outside the jurisdiction of the tribunal, and that would be a jurisdictional objection by characterisation.
Okay, thank you.
That's all I wish to say on Article 5, my lords, my lady. Last point on the treaty is on Article 6. Now, we can put it on the screen again just so that we all remember it's the expropriation provision. It's CB 22.4. Now, my learned friend's point here is only relevant to the date of commencement variant of the objection before the court. It is not relevant to the contention that the claimant must have held the asset at the date of the breach. And that's because if that is the objection, the claimant can still have a claim for expropriation, provided, of course, it held the asset at the date of the alleged expropriation. So that's why this point goes to the date of commencement variant. So just addressing the point's impact on that variant, I have two short points. The first is the good faith point that was discussed. It was suggested that when I referred to good faith as part of the interpretive process, that was wrong, and I was really talking about good faith in the performance of the treaty. Now, that's a point that we see claimants take often enough, arbitral claimants, I mean, and with respect, it is incorrect. Could we please, operator, go to Phoenix, which is LA, tab 6, and we'll go to page 44. It's in hard bundle 1, if the court wishes to look there. Now, as we can see on the screen, this is where the tribunal is discussing the need to interpret offers of arbitration to cover bona fide investments. If we can go over the page, please, operator. We can see there, we'll start at paragraph 109, the Washington Convention, meaning the ICSID Convention, as well as the BIT, have to be construed with due regard to the international principle of good faith. Some explanation is then given before in 110. Therefore, ICSID tribunals which have relied on this principle in order to determine whether or not there existed a protected investment have often relied on both dimensions of the principle. In my submission, entirely normal for the type of good faith considerations I mentioned, including to decide whether or not an investment is a protected investment to apply. Second point on this, my lords, my lady, just while I'm on the date of commencement variant, so variant number 2, I just want to make sure a related point is clear. It's something that I have touched on, but may bear just repeating given the exchanges between the court and my learned friend. Nobody is disputing that to be able to accept the offer to arbitrate, a claimant needs to be an investor at the date of the commencement of the arbitration. That is common ground between the parties on the Diag Human appeal. The only issue on that side is whether Diag Human qualifies as a Swiss investor under Article 11C or not, which again, it's common ground, needs to be satisfied and needs to be satisfied at the date of commencement of the arbitration. But in this appeal that I'm handling, on the second variant of the objection relating to date of commencement of the arbitration, the issue is whether there are additional requirements beyond simple nationality to be an investor, i.e. to qualify as an investor at the date of commencement. Is it enough just to be Swiss, or does one still need to hold the investment? So it's an additional point beyond the pure investor point on this second variant of the objection. I just want to be clear on that. The court may well have the point, because just to repeat, nobody is arguing that one does not need to be an investor at the time of the date of the commencement of the arbitration. My lords, my lady, you'll have probably noticed.
And the argument against you is variant 2 isn't open to you, so there's no need to address that point.
Indeed, my lord, and I'm going to come to the scope point. I'd rather put that behind the treaty in the cases, so I'll come to that momentarily.
But when you say nobody is arguing that date of commencement of arbitration is the relevant moment at which to decide whether someone is an investor, it just doesn't arise on the argument as it's put against you.
You're quite right, my lord, that the substance of the point that I've described is subject to my learned friend's case that the second variant is not live before the court, so you're entirely correct about that. My lords, my lady, that's what I wish to say in reply about the treaty. I'm now going to take some of the authorities that my learned friend went to, but I'll try to do so relatively speedily. Can we please start with Elliott and Correa? Now, there are some obvious points, I submit, that undermine my learned friend's reliance on that case. I can take them relatively quickly. There are 4. The first is it's under appeal, as my Lord Justice Mayles noted. So it's rather taking a chance by my learned friend to say the principles therein are correct. The second point, as my learned friend rightly noted, is that the disputes clause and the scope clause in the Korea-US Free Trade Agreement are vastly different to the clauses in issue in this BIT. In those circumstances, I suggest that the authority needs to be treated with some caution. The third point is that even if one does say that express language is needed in order to make an objection characterized as jurisdictional, we do have express language in this treaty, which His Lordship held was not in the Korea-United States Free Trade Agreement. I've already referred the court to the limitations on jurisdiction in Article 2, which are express language, which provide those limitations that apply to the entire treaty, including Article 9. As such, if one is looking at Elliott and Correa and saying the animating principle therein is the need for express language, we say that the jurisdiction conferred by Article 9 in this BIT is limited by express language. The last point in relation to Elliott, if needed and with respect, is that we would say the statement of principle is incorrect in that case. Now, it's not my job to appeal Elliott, but I do just want to show paragraph 37, subparagraph 3, which is LA/29.1/14, hard copy bundle 7. The court will recall, if we go to the top of the page, please, thank you. The court will recall that subparagraph at the top of the page, where there is no express limitation in the offer to arbitrate, including for that purpose those which arise from the use within the offer to arbitrate of defined terms. There is likely to be a greater challenge in persuading the court that the offer to arbitrate is limited beyond its express terms. That simply reflects the application of the VCLT principles of interpretation to the arbitration offer in a treaty. Now, with respect, that is not aligned with the readiness with which the International Court of Justice and the Alcor Tribunal and those other authorities that I've already mentioned identified a temporal jurisdictional limit in those treaties based on no express wording in the offer to arbitrate. And is also not aligned with the obviousness, I submit, with which one must apply a territorial jurisdiction, in this BIT at least, even though, again, there is no express wording on that in Article 9. Indeed, I would go so far as to submit that this proposition is not, as his lordship put it, an application of VCLT principles. Rather, it is an example of what Mr. Dunning quoted from Gardner as the fleeting starting point for interpretation, totally ignoring, for instance, the principle of effectiveness that Mr. Dunning explained, which must be applied in this treaty to read Article 2 alongside Article 9. Coming now to Agarwal in the judgment of the Paris Cour d'Appel, 3 short points on this authority, my lords, my lady. First, it's on appeal to the Cour de Cassation, so same point as to Elliott. Second, my learned friend accepted that the treaty at issue in that case does not have a provision like Article 2.1 in it, Article 2.1 from our treaty in it. So it's a totally different interpretive exercise in my submission. We have expressed terms in Article 2.1 and they impose a temporal jurisdictional limit. Third point on Agarwal is that this doesn't need to be decided, of course, but if necessary, the Czech Republic would say it is wrongly decided. It is contrary to consistent cases, which are not even disputed by the defendants in these proceedings, that there is no jurisdiction over alleged breaches at the time before the claimant had the investment. That's one of the objections to jurisdiction that I have said situates the objection that the Czech Republic is advancing here, in which the cases have been very clear in saying is jurisdictional. Those cases include the judgment of Mr. Justice Butcher in Tatneft, and indeed you can see several further cases outlined at paragraph 18 of my skeleton. When one contrasts that with paragraph 73 of the Cour d'Appel's judgment, on which my learned friend relies, one sees that it is at odds with that consistent line of approach.
Yes, we probably have enough to do without deciding whether 2 cases which themselves are under appeal are correctly decided.
I sympathise, my lord, I sympathise. Trying to keep up the pace, Phoenix and Vöcklinghaus. There's just one point of detail to address on Phoenix. My learned friend suggested that there was, in fact, no point in issue as to whether the tribunal had jurisdiction regarding events post-dating the sale of investment. That is incorrect. I won't turn it up, as in any event, I really rely on the formulation of principle from that case. But one can see it from paragraph 44 in that award that there was a complaint regarding denial of justice based on the process before the local courts, which was still pending even at the time of the arbitration, so well after the disposal of the investment. But the point that I wish to make about Phoenix and Vöcklinghaus, and maybe slightly broader, is that these are the awards that have considered to some extent, the post-dating breaches objection. And they have concluded that that is a jurisdictional objection. Would it be of assistance to the court to have more awards or awards with longer analyses? Yes, of course. But these are the awards that we have, and they support the Czech Republic's position. By contrast, as the court will have noticed, the defendants have not identified any awards supporting their view. There is no legal authority saying that a post-dating breaches objection is one of admissibility. Likewise, there is no legal authority saying that the date of commencement objection is one of admissibility. And to confirm that I'm not being careful with words, I also say that I'm not aware of any authority supporting the defendant's position on those two propositions. Now, I accept that the awards are not binding and they will only be taken for the extent of their persuasive value. But when the approach to the identification of relevant material, in the words of Mr. Justice Foxton below, was a drains-up approach, in my submission, there is some weight in the observation that the Czech Republic has identified these awards, Phoenix and Vöcklinghaus, on the post-dating breaches objection, and the awards at page 21 of my skeleton on the date of commencement objection, all of which say that the objection is jurisdictional, and the defendants have identified no award saying that the objections are one of admissibility. I appreciate that's a contextual point, but I do say in the circumstance of this case, it has some weight. Coming now to the penultimate case, Alcor in Czech Republic. The court has heard a lot about Alcor and spent significant time reading it. But just to address the discussion yesterday focused on the words, who invest in the treaty at issue in Alcor. My learned friend described that as distinctive language, including as it was in the present historic tense. With respect, the first point is that does not answer the points that I made about Alcor on Tuesday, and I continue to rely on those without repeating them. But further, that wording of who invest does have its analogue in our treaty. The word buy that appears in investments by investors plays that same role. That wording is particularly in Article 2.1 as we've seen, but it's actually all the way through the BIT as I explained on Monday. If my learned friend is relying on who invest as distinctive language for the purposes of Alcor, then similarly one ought to rely on investments by investors as the distinctive language relevant in this treaty. My lords, my lady, the final case is Azerbaijan and Armenia by the ICJ. I'll be very brief. The court will recall that this case involved the court reading in a temporal limitation into the compromissory clause, even though it wasn't stated in that clause. And then it held that that was a jurisdictional limit in the context of it being suggested that it was either jurisdictional or admissibility. Now, my learned friend didn't engage with the point at all and didn't take the court back to paragraph 45. Instead, the defendant's position was to refer to two opinions of single judges of the court. Three very brief points here. Those were the two judges who dissented on the characterization point. Second, it was only 2 judges out of 17 judges that were on the court. Sometimes it's forgotten just how many judges are appointed on the ICJ on a given dispute when ad hoc judges are added.
I think there were quite a lot of separate opinions from other judges in that case as well.
That's right, my lord, but one can imagine that the parties in this case have been so thorough in their approach to the identification of legal authorities relevant to this issue that those other separate opinions or individual opinions did not dissent on the point of the characterization of the objection as jurisdiction. Third and last point on this case is that in any event, the very fact that the 2 judges reached that dissenting view and characterized it as admissibility shows that the court clearly turned its mind to that issue, and the court by large majority favoured the position that the Czech Republic advances here. Now, my lords, my lady, the last point of authority to deal with is my learned friend's reference to Professor Douglas's text, which he referred to without going to it, for the general distinction between jurisdiction and admissibility. But if we can just look at it briefly, please, operator, LA 32.7. One sees paragraph 311 on the screen. It's hard copy bundle 7. An objective test to distinguish between preliminary objections relating to jurisdiction and admissibility is therefore required. Principles are twofold. First, if the preliminary objection were to be sustained, would it lead to the conclusion that it is inappropriate for the tribunal to exercise its adjudicative power in any circumstances? If the answer is affirmative, then the issue is properly characterised as one of jurisdiction, and the possibility of judicial review is justified. That is, of course, the Czech Republic's position. It is my case that, if the current objection succeeds, it would never be possible for the tribunal to exercise its adjudicative power over the claims affected. So Professor Douglas does have a general discussion about jurisdiction versus admissibility, but when it comes down to it, at paragraph 311, the ultimate test, or the ultimate litmus that Professor Douglas identifies, supports my client's case. Now, my lords, my lady, the penultimate point before I turn to the issue of scope relates to section 30 of the Act. It was suggested that this requires the court to approach objections from an English policy perspective. But in my submission, section 30 in its terms is just neutral. There needs to be an issue about the existence or scope of the arbitration agreement, and that is a substantive jurisdiction matter. As a matter of law, therefore, there is no room for a uniquely English principle of characterisation, or indeed recharacterisation of an objection. In an investment arbitration, a question of the existence or scope of the arbitration agreement is an international law question. I don't understand that to be disputed between the parties. It's a matter of international law whether the arbitration agreement exists in the section 31A sense, or what the scope of the arbitration is in the section 31C sense. So therefore, substantive jurisdiction in section 30 is referable to that law of the arbitration agreement. Now, it may well be the case that the practical consequences of an objection being characterised as jurisdictional or admissibility may be different in that practical way in investment arbitration compared to English law. But that doesn't change, as a matter of law, the meaning of substantive jurisdiction in the section 30 sense, which in the context of an investment arbitration is ultimately a question of international law. Now, my last set of points before I come to scope is just to deal very quickly with three short points that arose yesterday. Now, first, my learned friend referred to the Respondent's notice in this appeal and said an objection to standing must be an objection to admissibility. As I submitted on Tuesday, that view is wrong. I showed the court how international law tribunals sometimes use the concept of standing as a reference to the jurisdiction of the tribunal. I took the court to Alcor at paragraph 252 in particular. That's at pages 65 to 67 of the day 2 transcript. I'm not going to repeat the point, but that is the answer to my learned friend's point, and he didn't go back to that paragraph. The second short point before I turn to scope is that yesterday there was an exchange about how an investor can mitigate losses if they are unable to sell their asset without losing jurisdiction. Here, my learned friend submitted, and I quote with respect, "It is certainly a very complex requirement for an investor, and it raises questions about how does an investor meet an obligation to mitigate losses in those circumstances if they have to hold on to something so that they can keep their treaty rights." Now, again, it's important that the clarification I gave earlier applies here. This point is relevant only to the second variant of the objection before the court, the date of commencement point. It is not a point relevant to the first objection, which is simply that the claimant must have held the investment at the date of the breach. But on the substance of my learned friend's point, it's not a complex issue at all, and it doesn't raise difficult questions. The investor just accepts the offer to arbitrate before selling. The Czech Republic's case is not that an investor must hold on to the investment forever in order to be able to sue. That's not the effect of it at all. There is no doubt that the sale of an investment after the start of an arbitration does not affect jurisdiction. Again, that's Alcor paragraph 255. So in my submission, that point does not go anywhere. Last short point before I come to scope. I just want to clarify a point that I think may have led to some confusion that began with me, and I do so with apologies. In exchanges between my learned friend and my lady, Lady Justice Andrews, I was reminded that it was said that my point about the default in international law of no consent by states to jurisdiction was circular. Entirely my fault, and I should clarify that the point is not that the default of no consent means one should find no consent in an arbitration clause, or even that one should read the arbitration clause narrowly or restrictively. The point is lighter touch than that, and some may say Australians don't thrive at light touch points. But what I intended to communicate is that When seeking a proper and balanced interpretation of a BIT, including its disputes clause, one does not only consider the perspectives of investors and the desire to promote investments by investors. As a factor playing into the ascertainment of the scope of a consent to arbitrate, like in Article 9, it is to be considered along that promotion and protection consideration. The point about the default being that there is no consent to jurisdiction by states in international law. It's the balance of considerations, only one of which is the default of no consent on which we rely. Essentially, one doesn't just assume that these treaties are trying to achieve maximal foreign investor protection at the cost of all else. In the end, my lords, my lady, it's just a small point, but I hope I clarified. The last point that I will deal with is the scope of objection, as my Lord Justice Popplewell anticipated. Now, on this point, my learned friend's case is that the date of commencement variant, variant 2, is not open to the Czech Republic. My learned friend showed you certain documents, but not all of the documents. I'm just going to go through them quickly. Start with the pleadings. Operator, could we put up CB 28.7? This is the amended particulars of claim. And when it comes up, one can see paragraph 4 is the relevant paragraph. I'll just pause to allow the court to read it, but it's the first sentence and the last sentence that might attract most attention. So my learned friend says that the scope of the objection is limited in effect to only the last sentence in that paragraph, but one can see in the first sentence the date of commencement point being put. We feed through now to the amended defence operator at CB 29.9, and the relevant paragraph is paragraph 14, which has subparagraphs. And one can see in 14.1, the defendants addressed the point about investments at the time the arbitration was commenced. And over the page, please, operator, at paragraph 14.3, one sees the point about the post-dating breaches objection. We then feed through to the next pleading, which is the amended reply. Operator CB 3013, paragraph 27A. I'll just allow the court to read that to itself. First sentence, date of commencement. Third sentence onwards, post-dating breach. That then brings us to the March judgment. I can go to it if the court wishes, but we may all be familiar. We see in paragraph 63 that his lordship records the objections in the proceedings below, and it was subparagraph 7 to 9 that recorded the objections relevant to this appeal. And that, of course, is where, as my Lord Justice Popplewell noted, the reference to the commencement of the arbitration was recorded. My learned friend then made reference to paragraphs 121 to 122 of the judgment. In my submission, these paragraphs may relate to the effect if the jurisdictional objection succeeds on its substance, i.e. after June 2011, there is no investment and hence no jurisdiction. And there will perhaps be debate before the High Court about what is meant by those paragraphs, depending on the result of this appeal, but also in light of his lordship's judgment in October. But that is a matter for another day. What is not being said is, anywhere in these paragraphs, is that the jurisdictional objection as recorded in paragraph 63 no longer has a date of commencement component at all. Now, my learned friend then took the court to the ground of appeal for this appeal, and perhaps that was the focus of his submission, operated CB/2, which should have only one page. You can zoom in on that paragraph. The court can just read the first two sentences to themselves because that reflects the language of the judgment. And I just wish to pick up at the third sentence. In particular, the court should have held that Article 9 of the treaty does not contain an offer to a putative investor to arbitrate a dispute or claims in respect of conduct by the state taking place after that person no longer holds the relevant investment. So that language in the third sentence is recording Article 9 does not contain an offer to a putative investor to arbitrate a dispute, then a separate situation, which is the post-dating situation, after that person no longer holds the relevant investment. Now, this text was, with respect, rather quickly sort of whizzed over in my learned friend's submission. But in my submission, that does capture the commencement objection. As I've explained, the putative investor point is a reference to variant 2 of the objection. And indeed, the judge was alive to this, including after granting PTA on the basis of this ground of appeal. If we can go to his consequentials ruling from October, it's at CB 24, but page 6 is the relevant paragraph. My learned friend, in fairness, did refer to this, but didn't go to it, so it's important I submit that the court sees paragraph 17.
Not too fast. Or 1 or 24.
Yes, I apologise, my lord. I suspect you understand why I'm moving at speed. And it's the second sentence in paragraph 17 that my learned friend referred to. For example, is it enough for jurisdictional purposes that Mr. Stava had an investment at the date of the Boyar letter breach, which is no longer capable of being disputed, with the issue of the effect of any subsequent disposal of the investment going to the merits? Or is it necessary that Mr. Stava had an interest in the investment both at the date of the breach and at the date of the commencement of the BIT? Depending upon the answer to that question, various consequences may follow. Now, his lordship is clearly conscious that should the issue be characterised as jurisdictional, what could come back to him on the substance was both limbs, both variants that we have been discussing. Now, from the pleadings and the judgment, the ground of appeal and ruling 1, in my submission, both limbs are indeed reflected. And the last point, which I'll take very briefly, my lords, my lady, is that this does arise in my learned friend's skeleton on this appeal before this court. Could we please go to that, operator? It's at CB5. And could we go to page 16, please? This is the section which my learned friend took the court to yesterday, I think, where the defendants deal with the core point about treaty terms. And if we go over the page, one can see the point in paragraph 41 that my learned friend took the court to and spent some time discussing. That's where defendants say the Czech Republic is reading into Article 9 a requirement and depicts how they say we, in effect, are editing Article 9.1. And when my learned friend was addressing this, I think he indicated that the date of commencement was not something that was being thought about by the defendants in this part. But if one then goes to the next two paragraphs, 42 is a recitation of treaty interpretation rule. And then we come to 43, which is where the defendants engage with the substance of the objection. This is where they make their point about expropriation that the court has heard more about during this week. One can read it all, but in the interest of time, can we just go over the page, please, operator? And I start at the 7th line from the top. If one takes the most extreme example, direct expropriation, once that has occurred, the investor no longer has an investment in the host state. If a temporal requirement for jurisdiction were read into Article 6.1, requiring either the investor hold the investment at the time of the breach or at the time of commencing proceedings, then no tribunal would ever have jurisdiction, and so on. So this is their central point, if I can characterise it that way, about expropriation, and the defendants are addressing both limbs. It is not a point against me that they have done this briefly in their skeleton. This court is, of course, not deciding the substance of the jurisdictional objection, instead only its characterisation. And it's entirely sensible that both variants will be treated and answered together as jurisdictional. It's also entirely sensible that they are dealt with compendiously in the way that they are here. I will just very briefly note for records on the transcript that my learned friend also spent some time in the appellant's notice. He went to section 4, which is the other information section on page 4. Pardon me, he went to section 5, which is the other information section on page 4. But section 9 is on page 6, and that is the section, what are you asking the appeal court to do? And one can see there that that is framed as seeking an amendment of the order of Mr. Justice Foxton, so that paragraph 4 of the amended particulars of claim is included in the list of paragraphs that is not dismissed. Paragraph 4 of the APOC, the court will remember, clearly has a reference to both limbs. My lords, my lady, I apologise to the court and to the stenographer for the speed of the last half hour or so, but those are my submissions in reply.
Thank you very much. Yes, Mr. Dunning.
Just give me a moment, my lord.
Lord Verderame commenced his speech on the admissibility jurisdiction debate on the 2nd of June by accepting in unqualified terms that the question of whether Diag Human SE is an investigating Article 11C is a jurisdictional issue, and that's always been the case, and therefore I just wanted to start with that. In fact, that has been now confirmed by Lord Verderame. Another point that he mentioned during his speech, I'll just touch on this, is the alcohol against the Czech Republic case, which is entirely consistent with how I opened the case, drawing your attention to paragraph 165 of the judgment from which I appealed, namely that the time to assess jurisdiction where there is an issue as to whether someone is a qualifying investor, as there is here under Article 11C, is at the time of the commencement of the arbitration. That is paragraph 251 in Alcor, LA, tab 24, page 69. Of course, that doesn't detract from what the judge then said in paragraph 168 of the judgment, that on the facts of this case, we're assessing the position in 2017, 22nd of December 2017, the date when the arbitration was commenced, by reference to the position as at midnight, New Year's Eve on the 2012. So those are just a couple of points that arose out of what Lord Verderame said. Now, turning to the overall approach to the interpretation of the treaty, I believe we've handed up hard copies which you requested a couple of days ago, my Lord, of Gardner.
Yes, thank you.
Yeah, I'm not going to go through it all. I just wanted to make sure you've now got what you
Yes,
asked
somewhere.
for.
Yes.
As I submitted in opening, there is a single test and a single exercise of interpretation. It's not a staged approach, as you might in English law in certain contexts. So it's always said in international law there is one rule in the Vienna Convention on the Law of Treaties, and it comprises various factors that are identified in Articles 31 and 32, which must be taken into account together. Now, I call that holistic, but I'm not hung up on the word holistic. Can I just show you very briefly what the UK Supreme Court said about it in the Muhan case, which is in the bundle, Legal Authorities, tab 12, page 31, paragraph 64. And they quoted 4 or 5 lines down the International Law Commission, and which gave rise to Article 31. And the words I would draw to your attention in that quotation, that the paragraphs are intended to, this is the last 2 lines of the quotation, indicate that the application of the means of interpretation in the article would be a single combined operation. And in fact, although they don't quote the ILC report any further than that, in the ILC report itself, the Commission said that all the various elements, as they are present in any given case, would be thrown into the crucible, and their interaction would give the legally relevant interpretation. Now, I paraphrased all of that as holistic. I'm not, as I say, you can completely throw that phrase away and look at what the Supreme Court has said.
I don't think we have Muhan in hard copy. Can you just tell us what the law report reference is?
If we could go to the first, for page 1, please, DPE authorizer.
Oh yes, that will do it, won't it?
It is 2015 appeal cases, page 901.
Thank you very much.
Now, there's then another point, a separate point. There was a suggestion by Dr. Parlett that the point I made about Mr. Stava's inconsistency would only be relevant to how the treaty is applied and not to how it is interpreted. So far as that is concerned, Mr. Bastin shown you the Phoenix Award. In fact, he's just gone back to it after lunch today, demonstrating that good faith comes in relation to both interpretation and application of the treaty. And I think your lordships have got the point, but the point I want to just stress in relation to what we say is not in good faith is this. My learned friend, Mr. Riches in particular, talked about powers that Mr. Stava had that he could have exercised under the trust. But the court has to bear in mind two things. One is that he didn't exercise those, that had not exercised those powers as at the 31st of December 2011. And then the court has to ask itself, well, why, in the circumstances then existing, had Mr. Stava not exercised those powers at the 31st of December 2011? And there's an obvious answer to the second question, which is that he'd only just set up the trust. On one view, the shares didn't go into the trust until midnight on the 31st of December 2011. And Mr. Stava's own evidence as to why he set up the trust was that he did it for two purposes: succession planning and asset protection. Now, for both of those purposes, the shares had to be in the trust and outside his control. So, as at the 31st of December, once the shares are in the trust, he is then enjoying the benefit of the structure which he voluntarily created. That is to say, that if at any moment he were to pass away, his estate would benefit from his succession planning, namely that the shares are in the trust and not in his own estate, and his family would benefit from that. And whilst he remains alive, he personally has the benefit of asset protection, that he can deny, if anyone seeks to go against his assets, that these are his assets. Now, this was his own evidence as to why he entirely alienated his interests in these shares. And that there's no evidence that that wasn't still his motivation as at the 31st of December 2011. Now, Mr. Richards says, well, in May this year, just before the second trial and after the first trial, he requested the trustee to execute a deed which gives him the right to have the shares transferred to him. It doesn't in fact transfer the shares to him.
it gives him the right, supposedly, to have the shares transferred to him. Now, whatever may be the circumstances now prevailing, maybe he doesn't any longer see the need to have that succession planning benefit that he did when he set up the trust. Maybe he doesn't see the need to have protection against third parties any longer. But at the time, as at the 31st of December 2011, 1st of January 2012, those were the reasons that he set up the trust, according to his own evidence and according to the findings of the judge. And there's no indication that they were not the reasons why, as at that time, he hadn't exercised these powers that my learned friend seeks to rely upon. Now, just move on to a separate point. My learned friend, Dr. Parlett, put in a case which was said to show that international law adopts an evolutionary meaning of the terms in a treaty. This was the Costa Rica and Nicaragua case, which I don't think has gone yet on top us, although I'm hoping it will do at some point, but you have a hard copy that was handed up to you. And she referred you to paragraph 66. Do you have that, my lord?
That was 44.
I've got it, yes.
Yeah. Now, this was a case where there was what was intended to be a perpetual treaty between two countries, found to be interpreted about 140 or 150 years later. And she referred you to paragraph 66, but I would like to refer you, if I may, to paragraph 63. And at paragraph 63, the court said this: "It is true that the terms used in a treaty must be interpreted in light of what is determined to have been the parties' common intention, which is by definition contemporaneous with the treaty's conclusion." So that's the general position, and it's exactly what I submitted to you. If in the case of what intended to be a 100-year treaty, you can infer that the parties must have, and this is paragraph 66, been aware that the meaning of the terms were likely to evolve over time, and then you're deciding a case about 150 years later, then, and there is some evidence that the meaning of the term has changed, then what Dr. Parlett drew your attention to may well be applicable. But the general position is that at paragraph 63, to which I've made reference. And just in case you think that this is a perpetual treaty, it is not. Article 12 limits it for a period of 10 years, and then it's refreshed 5 yearly after that. And what's more, there's no suggestion here that the meaning of the term control has changed since 1990, or that the development of new types of legal entities should affect its meaning. So I just wanted to make good my point, which I made in opening, and which I respectfully submit is not countered by this case, that the position is judged as at 1990. Turning to the object and purpose as reflected in the preamble, on the Respondent's case, this treaty, as my Lord Justice Popplewell pointed out, protects investments which do not have any Swiss economic or legal interest. As his example of a German company wholly owned by French interests, but managed and controlled for practical purposes by, for example, a CEO or board of Swiss nationality. My learned friend's interpretation, that would be a qualifying investor, and yet it is clearly not what the preamble to this treaty contemplates as a protected investment. So there's that point on the preamble, which chimes with my learned friend or Justice Popplewell's example. There is also the point which I made, which is that the preamble favours an interpretation of the treaty which creates certainty and predictability. Now, I think Dr. Parlett made just a small effort to challenge that proposition, which I respectfully suggest is correct. But if authority is needed for it, could I show you a short extract from a book by Sellecuse, which is in the bundle, I think, put there, possibly by the respondents, LA tab 33, page 1. This is Jeswold Sellecuse, 3 Laws of International Investment. And on page 2, right at the beginning of the book, investment protection, I could just show you the first sentence there. The primary motives behind the rapid expansion of international investment treaties were the desire of investors from capital exporting states to invest safely and securely abroad, and the need to create a stable international legal framework to facilitate and protect these investments. And if I won't take all of this, but then the next paragraph, the lack of consensus on the customary international law applicable to foreign investments, discussed in chapter 13, created further uncertainty in the minds of investors about the degree of protection they could expect under international law. To decrease their uncertainty and counter the threat of adverse national law and regulation, the home countries of these investors attempted to conclude a series of treaties that would provide, something's missing there, clear rules and effective enforcement mechanisms. And so, at a very high level, my lord, the purpose of all, possibly, certainly most of these treaties, is to provide a level of certainty for prospective investors from capital exporting countries. And that generic purpose, if I could call it that, of these treaties, is reflected in the wording specifically in the preamble in this particular treaty. And the judge himself accepted part of my argument here, because he accepted that the test of legal control is easier and simpler to apply, but then in the final analysis at paragraph 215, he did not give weight to that consideration. And while I'm on this point, if I could just remind you of the reference that came up yesterday in the BMEX case, which if we could just call it up briefly on the screen, it's Legal Authorities, tab 20, page 86, paragraph 220, the last 2 lines, after Roman 2, the end of the penultimate line, de facto control will typically and logically present a greater evidentiary challenge. Greater evidentiary challenge means greater uncertainty and greater unpredictability, contrary to the objective of this treaty, in my respectful submission. And so we respectfully submit that the preamble favours certainty and predictability in line with the general background, and the simpler test, or as I perhaps would prefer to call it, the straightforward test, which presents less of an evidentiary challenge, is the legal test of requiring legal control. And there is, in my respectful submission, no good reason to interpret the preamble to support a wide pro-investor interpretation of Article 11C, so that it applies to bring in what can be an entirely de facto test without any legal right of control over the relevant entity, or as I put it in various parts of my submissions, de facto untethered to any legal right of control over the relevant entity. And if one was to bring in that as the relevant test, then every case would simply be an impressionistic one to be decided by the relevant tribunal when a dispute arises with no fixed or certain legal standard, potentially difficult to prove or disprove, especially where, as in the present case, there is no legal right at all. And this is why we believe that Professor Karen, one of the most eminent jurists in this area, wrote in the ADT and Bolivia case that a de facto test is too vague or so as to be unmanageable. And I took you to that before. My own friend, Dr. Parlett, also referred to the Energy Charter Treaty and its definition and understanding as what are investments in Article 1.6, something which he did before the judge and who did not accept that argument. And in my respectful submission, he was correct not to do so. First of all, the Energy Charter Treaty is a substantial multilateral treaty with I think about 50 parties, although it changes because the EU is not very happy with the ECT these days, so quite a lot of leftists now. The influence of Switzerland or the Czech Republic when it was drafted is likely to have been non-existent or minimal. And this was, just to set the context, we're talking about around about 1990, the so-called end of history, the end of the Soviet Union and the Iron Curtain coming down. And this was a treaty which was driven by US interests following the collapse of communist states. Secondly, the ECT has no connection to this BIT. And thirdly, in any event, the de facto control test in Article 1.6, which is what my learned friend Dr. Parlett referred to, of the ECT, is a red herring because it concerns the ambit of protected, quotes, investments. It doesn't relate to investor. The definition of investor in the ECT is the straightforward one in Article 1, subparagraph 7, to which I took you to when I was taking you through the UCOS case. Turning then to the protocol, it is correct. We have it, sorry, let's just start again. We have in the protocol a provision that says that the state may request proof of such control. And it is correct to say that the consequences of recognition or non-recognition as an investor following the provision to the state of such control, of proof of such control, are not spelled out in the protocol. But let's just think through. I'm trying to read anything into it, but let's see. There are two possibilities. The state asks for proof of such control. The investor produces something, and the state says, "We're not satisfied, and you are not recognised as an investor." If that is what happens, then the investor will be taking a risk going ahead and investing, not having been recognised by the state as an investor. And one should bear in mind that that investors don't just take one decision to invest in a country. They make decisions to make further investments from time to time. Investment's not going well, not generating enough cash yet. We need to put more capital in order to get to a cash generating position. So it would be risky for the investor either to go ahead and invest if it's not been recognised, or to carry on investing more money if it hasn't been recognised. If, on the other hand, when this process is operated, the investor has been recognised, then it would be of considerable comfort and likely to give rise to an abuse of rights or good faith argument against the state if it subsequently changed its mind without a material change of circumstances or without saying that it was misled by the original presentation by the investor. So there is a point in having this protocol. And what matters for my argument is what, and the words are, proof of such control is likely to look like. And one has to bear in mind that this is likely to be a fairly simple process at an administrative level involving state officials, something which I submitted in opening and Dr. Parler didn't take any issue with. And in my respectful submission, that piece of context militates strongly in favour of what I call the straightforward test of legal control, for the reason identified in the case we've just looked at, that in practice and logically, it is far easier to apply that test. Now, Dr. Parler then made a number of submissions relating to proof if you apply the requirement for proof to subparagraph B. With respect, I didn't follow that because there is no requirement in the protocol to provide proof of the matters in subparagraph B. The proof of control requirement only applies in relation to subparagraph C. Now, it was, I think, at this point that Dr. Parler made a comment about Mr. Smith, the author of the chapter on the Swiss BITs that I took you to in my opening. And she said he wasn't an eminent judge, publicist. That's perhaps correct, but it's rather unfair not to say, as the contents of the book reveal, that he was, when he wrote that, the deputy head of the International Investments and Multinational Enterprises Unit at the Swiss State Secretariat for Economic Affairs. And he has extensive experience of BITs and free trade agreements and negotiating the same on behalf of Switzerland and EFTA. In short, when he wrote this article, he was writing about something with which he was intimately familiar. And what we do know from Mr. Smith's chapter on Swiss BITs is that having a protocol with a right to request proof of control was a common feature of Swiss BITs. We see him referring to it, and we've seen examples of at least 4, and I suspect there are more Swiss BITs that had a requirement for proof of control. So it's certainly not something which is unique to the BIT in the present case, but no award has thus far considered the significance of and the meaning of proof of control. So we respectfully submit that all the states that agreed with Switzerland and Switzerland itself to have a protocol such as this in their treaties must have thought that the provision had some significance and that the words should be given meaning. The principle I was groping, the Latin principle I was groping for yesterday, which you'll find in Gardner on page 4 of that extract, is ut res magis valeat quam periat, which is the Latin way of saying we should give meaning to the words rather than not give any meaning to them. Now, my next point is that if a legal right of, we can test the argument this way, if a legal right of control is required.
Sorry, just do we have that part of the award where our arbitrators consider protocol and proof of control?
It was never argued.
It wasn't considered in the award. I'm not to say that. I mean, I don't know whether that was. I haven't got in front of me all the submissions.
Okay.
But
Right. Not in any of
it
the.
was certainly considered by, it was certainly something I pressed very strongly before Mr. Justice Foxton.
Of course, yes. No, I was just struck by the fact you said no award thus far has considered this, and I wondered whether our
These-
arbitrators
No,
had.
no, they haven't.
Maybe they weren't asked to.
I think that's quite possible, given that.
So on your submission, the key point was not mentioned in all 1,103 paragraphs of the award.
This was a very, I mean, just point of setting. This, we spent a total, I think, 4 weeks in front of Mr. Justice Foxton, just on some points of jurisdiction. The hearing before the arbitrators was 5 days remotely online during the lockdown on every single issue in the case. Merits, every aspect of the merits, every aspect of quantum, and all the jurisdictional
we're
points.
seized of the point now, one way or another.
We are seized of the point. It was certainly before.
Wondered if they had said anything about it, but the answer seems to be no.
No, they haven't, and it may well be that it wasn't drawn to their attention. I'm not
Okay.
disputing that. If it is the case, I just don't know if it is or not. Now, the next point. If a legal right of control is required, as we submit that it is, there's a more straightforward test, then that would be a relatively strong and legally meaningful connection between the relevant third-party state from whom the putative investor comes under 11C, because it's always a third party, possibly, it said it could be possibly Switzerland, but that's a matter which I'm not sure been fully argued, and the putative investor state party. It would be a strong and legally meaningful connection. And on the other hand, if solely factual control would lead to the Swiss CEO and board and Justice Popplewell's example being identified as being in control, that would not be a strong and legally meaningful connection. It would be simply de facto and of no economic substance at all, because on this example, the Swiss CEO and board would have no skin in the game, as the phrase goes these days, so far as the financial fortunes of the German company is concerned. That would be entirely with the French company. Turning to the wording of Article 1 itself, the meaning of the word controlled, how to interpret the word controlled in that context. We urge upon this court that for the reasons given by Professor Douglas in paragraph 556 in his monograph, that's LA tab 23, page 60, and the following paragraphs thereafter, we submit that the question of the meaning of controlled in this context should be answered by reference to domestic law concepts of property law and company law. And Professor Douglas actually does analysis of the issue. He doesn't just list the cases or summarize the decided cases. He does an analysis, and in paragraph 556, and then developing it later in later paragraphs, these are the themes that come out of what the reason why he says that domestic private law concepts of property and company law have to be referred to. First and foremost, there is no public international law as such on what it means to have control of an entity. Okay, so I'm told I've given you the wrong reference. It should have been Legal Authorities, tab 105, page 7. I'm not sure how I got that transposed. Now let's start again. There is no public international law as such on control of an entity. So if one was to say that this is something that is exclusively governed by international law without reference to the domestic law position, then there is no rule, because it doesn't, international law itself per se, without incorporating the principles of law of civilized nations, doesn't have a rule on what it means to be in control of an entity. That's the first point that he makes. Second point he makes is it is desirable to have certainty and predictability, and you get that by referring to the relevant domestic private law concepts of property and company law. I won't repeat what I've said about certainty and predictability, but he gives this as a reason for this form of renvoi from international law to domestic law. And the third point is just a point of logic and legal analysis and logic. The relevant entity of which the status is being considered under Article 11C will be formed somewhere in the world under some system of domestic law. And there will be a domestic law governing, either through property law or company law, its relationship between the putative controller and itself. And it therefore makes sense to look at that domestic law to assess the question of control. And there is really no alternative. The alternative is the length of the Chancellor's foot, or whatever modern term one wants to use for the absence of any yardstick of any fixed or certain predictable test.
So you would say, looking at his paragraph 556, that rather than saying reference must be had to general principles of property law and company law, we should understand that reference must be had to the relevant domestic principles of property law and company law, rather than, if this is what he means, principles of property and company
Well, it
law
could be both.
generally applied among civilized nations, or something
It
like
could
that.
be both, actually. I'm not saying they're necessarily mutually exclusive, because I don't think there are any civilized nations which would deny legal effect to a trust relationship, or if and many civilized nations have general principles which, to put it positively, accord legal effect to a trust relationship.
But they differ as to whether the beneficiary under a trust has a property interest. For example, in English law, they do have such an interest. In Liechtenstein law, apparently they don't.
No, they don't under a wholly discretionary trust under English law.
Oh, no, I agree, under a discretionary trust, but even under a fixed trust, Liechtenstein apparently they don't. I think.
Well, there is no such thing as equitable ownership.
Yes.
Yeah.
And that's just an illustration
But I don't think there's no difference being identified so far as discretionary trusts are concerned. Fully discretionary trusts, where nobody has a right to benefit at all. That's not just the amount of their benefit is discretionary, but the actual benefit is not fixed.
Yes.
And you may benefit, you may not. There may be a total distribution to other potential beneficiaries. This is one of the reasons why, under a fully discretionary trust such as this, it's wrong, in fact, to call them beneficiaries. They are the class of potential beneficiaries, because they are not, in fact, beneficiaries under the trust. They are just simply identified as people who might conceivably benefit. But there is no difference that's been identified. For example, and this is relevant to another point that Dr. Parlett made, she said, well, it's different between the Guernsey Trust in the UCOS case and Liechtenstein law. Well, there is no difference because in both there is no property interest in a discretionary trustee. And the other paragraphs, my lord, I'm not going to read them all out now, but I took you to most of them, I think, in opening. 560, 561, 562. And in my respectful submission, Dr. Parlett hasn't responded to that legal analysis and the actual reasoning in these paragraphs. And her response, instead of grappling with the analysis and the reasoning, was to say, oh, well, this book was written 15 years ago and water has passed under the bridge since then. And there have been a number of cases that have relied on de facto matters. But none of that case law actually grapples with and gainsays the analysis in the book. And the reason why Professor Douglas's book is still referred to is because it is analytical and not just a list or a summary of decided cases, as many of the textbooks are in this area. And Lord Vodarami had it right when he said, a conceptual analysis can age a bit better. And that's what you have from Professor Douglas. Now, it's also the case that Dr. Parlett was very unfair to Professor Douglas when she said or implied that in the Italba against Uruguay case, he had changed his mind. That case was, first of all, he was one of a tribunal of 3. Secondly, the relevant part of that case was concerned only with the question of whether there was an investment. And thirdly, we can look at this, please. It's Legal Authorities, tab 81, page 82, paragraph 264. So this is the sideline passage. First of all, at paragraph 263, the tribunal says the evidence submitted by the claimant has been carefully examined, and the tribunal finds there is no evidence on the record to conclude that Italba was actually controlling Trubasol. So, in a sense, it didn't make any difference to the result, because the way the case was presented was one of de facto control, and they rejected it. But then in paragraph 264, they were quite careful to say that they didn't consider whether the notion of control was flexible and broad rather than strict. Another possible argument, and they said it would be futile for the purposes of this award. So I think the criticisms, the point sought to be made that in some way Professor Douglas has changed his mind is not borne out by this award. Moving on, Dr. Parlett referred to the directly or indirectly wording, but this is put into these treaties in order to enable companies in a chain, upward chain of holding companies, to be able to make a claim. It doesn't tell you anything about the test of control, merely by virtue of having the words directly or indirectly there. And in fact, it makes it much less likely that de facto control is correct, because if the right test was de facto control at every level in a hierarchy of companies, there could be possible arguments of de facto control at every level in the chain, and with even greater uncertainty and unpredictability. Now, the other thing that I would respectfully submit, which is the curiosity of the implications of the argument for which respondents contend on the true construction of Article 1.1c, is this. In many of these treaties, It's quite simple, particularly the early treaties. You have to be a national, or you have to be a legal person under whichever country's law. Here, the legal person test, that's to say 11B, has been made much more restrictive, because it's not enough to be a Swiss postbox company. You've got to have your seat there and you've got to have real economic activities there. So 11B is narrower. Now 11C, however, which applies to the whole world, and which, again, I'm contemplating Lord Justice Popplewell's example. If the test is of de facto control without share ownership in the company, this would be extraordinarily broad. And that strikes us as a way of interpreting Article 1 as a whole, which would be unsystematic. Our answer to that is that on that approach, there is a striking disparity between the effect of Article 11B and the effect of 11C. To qualify as a Swiss company, which is after all a Swiss company, and therefore prima facie Swiss and deserving of protection, it not only has to be a Swiss company, but it has to have its seat and its real economic activities in Switzerland. But to be a company from anywhere else in the world, you don't have to be legally controlled by a Swiss person or a Swiss company. You simply have to have someone who is a very, very knowledgeable, very expert manager, possibly even the former owner. I mean, it's not at all unfamiliar situation where you get a buyout for a company, for example, by private equity, for the existing management to be tied in for 2 years or 3 years to carry on managing. But that doesn't mean that the nationality of the company, the purpose of 11C, has not changed in accordance with the nationality of the new legal control, the new owner, the private equity firm, whatever vehicle it's chosen to make its investment.
Maybe a bit late in the hearing to start raising that, but well, I asked the question, control of what? The answer is control of the company.
Yes.
But control of what aspects of the company? On the one hand, you could have those who control the activities. On the other hand, you can have those who control the economic interest in the company. Now, I think the argument on both sides has tended to focus on the latter. Well, perhaps not. Which do you say it is?
Well, I say it is the paradigm case is owning the shares of the company.
That would be the latter.
And the more difficult case is if you don't have an absolute majority, but you have, as for example in the Van Piezold case, you have 45%, but there's some other feature which enables you to say that you control it. But that's not our case.
No, but that's all. That also is a case in my latter category. It's looking at control over the interests in the company, as opposed to control over the company's activities.
Can I show you something, and then which I was going to come to anyway? And it occurred to me that when I took you to the Gramercy case, I was a bit brief in just showing you one sentence, I think. And fortunately, Mr. Riches showed you a number of other passages in earlier pages this morning, and I just wanted to, as it were, stitch all of those references together. If we could just go back to that. It's this, because this is the case that says being a manager is not enough. Yeah. And if we could go back to that, is it? Yes, it's LA 89, LA tab 89. page 137. And in fact, these passages were diligently sidelined by the juniors earlier in this one. But this, I think, this is why I think it may be apposite in relation to your lordship's question. 632, which is page 137 on the screen. Corporations are organised at two levels, that of the owners and that of the administrators, e.g. in joint stock corporation, the joint stock corporation, the general shareholders meeting and the board of directors. Each level constitutes a separate organ, but cross-participation is frequently permitted. And then it says owners, be they known as partners, shareholders or members, are those who contribute the funds required by the corporation's development, stand to benefit or suffer from the entity's activities and receiving the remaining funds upon the corporation's liquidation. The administrative organ, be it a sole manager, general partner or a board, manages the affairs of the corporation and designates its officers. The administrators and officers are both the corporation's servants, authorised by the owners or the founding documents to adopt decisions on the corporation's behalf and in its interest. Administrators and officers normally receive a remuneration for their services and may or may not be subject to dismissal by the owners. Which separates owners and administrative officers is the business risk. That ultimate risk is always borne by the owners. Control of a corporation can only be exercised at the level of its owners, not that of its administrators or officers. The owners, not the administrators or officers, have an ownership interest in the company, and the owners are those who suffer the loss. The treaty grants protection to assets owned or directly or indirectly controlled by an investor, reinforcing the conclusion that control of a corporation must be exercised at the ownership level. And I adopt that, my lord,
Yes.
in answer to your question.
I see an analogy, but this is dealing with control of assets, not control of companies.
It is, but and then the bit I had, the bit Mr. Richards referred to this morning was a bit earlier than this, and the bit I previously referred you to was on the next page.
But it is in the, perhaps not sufficiently careful, but in the dichotomy I put to you, it is the second category. It's control of the company, in the sense of control of the economic interests of the company, the ownership interests of the company.
Yes.
Not the activities.
Yes, the daily or the business of the company is run by the administrators, but the entire company is controlled by the shareholders in general meeting, and that's ones who have the ownership.
This is an analysis which isn't necessarily, although it may reach the same result, based on agency. It's simply what you're talking about within the meaning of the word control, in the context of control of a company.
Yes, that's exactly what they say. That control means in this context something that's derived from ownership of shares. So I thought that might be helpful to show you that, just as I was coming to it anyway. Dr. Pollock came back to the judge's point about switching the nationality of the trustee, and she said it was a simple matter and unlikely to have a legal impact on something such as treaty protection. I've already been over why we disagree with this. We've addressed it in our main skeleton at paragraphs 38 to 40, with examples of serious consequences that can flow in law from changing the trustees, and in particular changing the nationality of the trustees. My own friend didn't grapple with the substance of the point, but she just simply repeated the point that the judge made, which we say is incorrect. It's not unlikely or improbable that changing the trustees or the nationality of the trustees would have some legal impact on something such as treaty application. Changing the nationality of a trustee is a very significant step and should only be taken with legal advice, and even then you might get it wrong, as they did in the case that we looked at when I showed you. Turning to the awards, can be relatively brief here because there aren't a huge number which we say have actually any assistance to you. We, as you know, rely primarily on ADT in Bolivia and UCOS. Now, of course, Dr. Parlett was right to say that there are many eminent people who sit on all of these panels, but they're not necessarily of the eminence of Dr. or Professor Karen and George Schwabel, who chaired the two cases that we rely upon. UCOS, and we handed up that coloured chart with the arrows and the organogram, it is not materially different from the present case. The fact that it was governed by Guernsey law and not Liechtenstein law makes no material difference. And if we, just coming back to that point about general principles of law of civilized nations, that is exactly the point that is addressed in the concluding paragraph of the reasoning about, you'll recall, about trusts being an institution around for hundreds of years, and there is no reason to upset or set aside the legal structure of the trust in Judge Schwabel's reasoning there. Now, apart from those two cases, the von Pezold case, which my learned friend initially said was her best case on the question of principle, this case certainly does not decide that factual control untethered to a legal right of control or ownership would suffice. Far from it. In that case, each claimant had a substantial shareholding. For those that didn't have a majority, it was held that they had, that there were factual elements on top, which could be combined with their substantial shareholding. In fact, there is no case that has been cited where factual control without any legal right of control over the company has been held to suffice to pass as control so as to establish investor status and thus jurisdiction under a treaty such as this.
But none of the individuals in that case had a legal right of control. They had a legal interest.
They had a
But they
proprietary
didn't have a
interest.
legal right of control.
But that's why I've always said that it's a property interest or legal right of interest. And it is a point I come back to, that the judge accepted both of those points, but then compressed them into a single phrase, de jure right. But actually, I always ran 2 points. One was no proprietary interest and no legal right of control.
So a non-controlling proprietary interest is sufficient.
I'm not saying that, but
Well,
but
what is the de jure requirement?
well, I'm not saying it's sufficient on its own, because we are dealing only with a 100% block in our case, and that is therefore there is no ownership and no legal right of control. And so our case is right at the end of the spectrum. Now, in my submissions below, the way that I differentiated between cases at that end and the other, and going towards the lower shareholding, is that once you no longer have 50%, then there may no longer be a presumption that you have control. And you may have to then, although you've got a proprietary interest, you may need to establish your control by reference to something else. So,
Facts.
well, not necessarily. because I was just about to say, in Van Piezold, one of the claimants established it by reference to a right of veto, which is another form of legal right. It's not a positive legal right to produce something, but it's a legal right to stop something happening. But I do stress that this court hasn't got to decide all the other cases that are out there that are not before it.
No, but in order to test the principle, you've got to look at the different shades of grey.
Of course, I
You can't
accept
look
that.
at black and white. And,
Of course, I accept that. But if you have no legal right, no ownership, and no legal right of control, in my respectful submission, the answer is clear.
well, that's really the nub of the point that you make, isn't it? At the end of the day.
And there's no case that holds, in a case such as this, that a person with no ownership right and no legal right of control can establish control for the purpose of establishing investment status of an entity simply by reference to the uncertainty of proving a certain factual situation. Now, then my learned friend said, well, actually, perhaps Van Piezold isn't my best case. The best case is the BMEX case. But again, that did not decide that factual control without any legal right of control would suffice. That turned on Article 1117 of NAFTA, which I couldn't find in the award, but it actually says this: an investor of a party on behalf of an enterprise of another party, that is a juridical person, that investor owns or controls directly or indirectly, may submit to arbitration under this section of claim. So the relevant phrase was owns or controls directly or indirectly. The tribunal held that there wasn't ownership in the sense required. And as for control, it looked at the three potential claims for control by the relevant putative controllers, all of whom had substantial shareholdings, again, in that case. Now, as for the three, they held that there was a legal right of control for in one situation. In the second situation, but this is where the veto power comes in, I apologize. Second situation, they said it was a legal right of control and a veto power, which combined with the factual circumstances was said to evidence control in that situation. And then they said the third situation didn't need to be considered. So it held that a person who had a substantial shareholding, but not an overall majority, then in that situation, the veto, and whether it was possible relying on other factors, would be relevant, but only where the person has a shareholding, has a property interest, and on the facts of that situation also a right of veto. So that doesn't get my learned friend home in relation to the facts of the present case. Turning to writing, I've really covered this largely, and I don't want to trespass too much on Lordship's time in relation to this. Obviously, I've discussed Douglas. I've referred again to Schmidt and his knowledge. The Schroyer paragraphs that the judge cited were paragraphs 322, 324, 325, and 330. 322 was all about investments under the ICSID gateway. 324 was again about the ICSID gateway. 325 was about NAFTA cases, Thunderbird and BMEX. I've mentioned BMEX, but Thunderbird was a case very unlike the present case, and ended up with them citing that the de facto control might be enough, but it would have to be proved to the criminal standard of proof, which rather stands out as an odd decision, but it also underlines the point that I've been making about the difficulties of proving a factual situation as opposed to the straightforward nature of a legal test of proving a legal right. And I would respectfully submit that the Thunderbird case is therefore not a reliable guide to anything. And then the final paragraph that the judge cited was paragraph 330, but that was rather generalized comment, mixing up a variety of the different contexts. And I respectfully submit, therefore, that the four passages that are before the court and the judge relied upon were really not very useful. As to form versus substance, this was very faintly pressed by my friend. She referred you to two cases of the four, I think, that the judge had referred to. I've already dealt with these in paragraph 52 of our skeleton argument, which is at CB tab 18, page 19. Neither of the cases supports the judge's pervasive reliance in paragraph 215 on form versus substance. And I would just say one more thing, that my learned friend referred to the Blue Bank case, but in that case, contrary to what Dr. Pilot said, the trustee was not the owner of the investment under the relevant Barbados law. And just look at that very briefly. So what she said I would like to correct. And this is LA tab 78, page 44. Paragraph 172, they say, in conclusion, Blue Bank as a trustee does not own the assets of the Qatar Trust. The tribunal has thus far reached the conclusion that Blue Bank has no ownership rights in respect of the assets of the Qatar Trust. So I'm not sure why my learned friend said that the trustee was the owner, but let's move on. Yes, can I now move to responding to Mr. Rich's? In his first of his two speeches, Mr. Rich's said that I was seeking to reopen the findings of fact made in Annex 3. But I noticed that when that was his introduction, when he then developed his submissions this morning, he actually gave no examples of me seeking to reopen facts in Annex 3. Just for reference, what the judge said in giving permission to appeal, and I take you to it if you wish, my lord, but it's in the order at paragraph 2, which is CB. Then I'll come back to that one. The ruling is at CB tab 24, page 2, paragraph 5, and the order CB 22. Ah, yes, that's what I've done. I've not put in the blue here. CB 22 at pages 3 to 4. Now, the combined effect of these is that the judge said that he couldn't contest his fact findings in the paragraphs which he identified at paragraph 5 in the ruling, which is at tab 24, page 2. But there's nothing there that prevents me from supplementing the fact findings, provided I'm not challenging them. Nor does it prevent me from citing the joint memorandum of the experts in order to explain the judge's fact findings. Now, just on paragraph 218 of the judgment, my learned friend Mr. Richards spent quite a lot of time on this yesterday, but I hope that I made clear in opening that provided that it was accepted on this appeal that this is a valid and effective trust, then we had no need for the arguments that the judge addressed in paragraph 218 of the judgment, and which we then had at the tail end of our skeleton argument. So I think he and I are ad idem that those aspects have fallen away because there's no longer any suggestion by the respondents that this was anything other than a valid and effective trust. Now, Mr. Richards said yesterday that the agency argument doesn't do justice to all the other rights which Mr. Stava held. And he said that the agency argument proceeds on a false premise, that everything that the claimants rely on was related to Mr. Stava's role as an agent of the trustee. Well, I don't ignore his other rights. I actually took you to his rights as protector. There are only two, and they are in 22 paragraph 1 and paragraph 22 paragraph 2 of the trust deed. But the learned judge held that none of his rights in any capacity, this is his finding at paragraph 171, amounted to him having a legal right of control over the company. And I'm not sure that even now, even in his respondent's notice, my learned friend has disputed that proposition. The only challenge to that is the agency challenge, and other than the agency point, the only challenge to that in the respondent's notice is by reference to the alleged right to exercise the voting rights attached to the shares. But then yesterday, at day 4, page 162, Mr. Richards conceded that this was one of the rights exercised on behalf of the trustee. Just pausing there. So we looked at the different hats. We looked at it in much more detail at the trial that Mr. Stava had. He was a settlor, but that didn't give him any rights of control other than to submit a letter of wishes or to communicate in some way his wishes to the trustee, which the trustee could have regard to for guidance in his role. Now, this was one of the features of the case which we were a little bit cross about at the trial, in that I cross-examined the daughters about the letter of wishes and Mr. Stava, and at least one of them, I think possibly two from recollection, confirmed that there was a document. It was never produced. It had been ordered to be produced, but we never saw it. But qua settlor, there was no right as such for Mr. Stava to do anything in relation to the trust assets. So that, though Mr. Richards referred compendiously to all of these rights, there was no right as settlor. Then as beneficiary, there was no right of beneficiary to control the trust assets. Even though the dramatic document with the Swiss flags on it had every single point that Mr. Richards was making, most of which failed before the learned judge. Even on that document, he didn't contend that as a beneficiary, Mr. Stava had any rights of control over the trust assets. And in fact, of course, in that regard, Mr. Stava wasn't a beneficiary, he was a potential beneficiary, just as all of the children and possibly grandchildren, daughters, and so forth. I think there were about 10 altogether, were all potential beneficiaries, but none of them had any rights of control over the trust assets under this entirely discretionary trust. So I dealt with settlor, dealt with beneficiary. Qua protector is the only one where there were rights, and those are the rights under 22.1 and 22.2 that could, in certain circumstances, be exercised so as to appoint himself, or, Mr. Richards said he could make a distribution of the assets to himself. But these are the points that we come back to that were not exercised. These rights were not exercised. And the reason they were not exercised is because the shares were in the trust in order to not be owned and controlled by Mr. Stava. That was the succession planning and asset protection purpose of putting them into the trust, so that it was deniable that he had any right in relation to them. So it isn't fair to say I ignored his rights. They're the only rights. And it's not fair to say that I ignored those rights in my opening, nor did the judge. And the judge made findings about them. But he nevertheless concluded, despite those findings, which were in favour of Mr. Riches to some extent, the judge did not conclude that Mr. Stava had de jure control as at the 31st of December 2011.
So, you say it's analogous to a case where you've got a non-Swiss shareholder of the relevant company, but there's an agreement between that non-Swiss shareholder and a Swiss national, under which the Swiss national has a right to have the shares assigned to it with the consent of X. It shows as a matter of fact that if asked, X would say yes. So nevertheless, you look at the control at the date that you're looking at. The 100% shareholder is the non-Swiss entity. That might change at a later date, is neither here nor there.
Yeah. And we say that is an analogy. Whether it's a perfect one, I can't decide on my feet. But it is an analogy, and that's why we talked about option agreements as well, because that was another analogy that was being proposed. But my key point here, in terms of bona fides or good faith in the implementation of this treaty, is Mr. Stava's own evidence is that he alienated these shares to get them out of his estate for succession planning purposes and for asset protection. So how likely is it, at the very moment when they finally vest at midnight on New Year's Eve 2012, how likely is it that at that moment in time he would have exercised any of these powers to get them back into his own name or under his own control again? It's extremely unlikely, because it would defeat the purpose of what he'd done. And so not only did he not do it, which is your lordship's point, but there was a very good reason why he didn't do it. And it is contrary to good faith, in our respectful submission, for him to seek to have the best of both worlds in the implementation of this treaty.
You would say still less likely at the end of 2011, when the law book transaction has failed.
Yes.
And the promise of negotiations from your clients has not been forthcoming, and in his view, your wicked clients are all the more likely to be coming after him and his assets.
Yes. And that's the point I was focusing on when I said New Year's Eve 2012. I was focusing on that particular point in time. So yes, the answer is yes. And just to repeat, the judge, I'm sure you've got this, but the judge made the findings at paragraph 61 Roman 4 in Annex 3, which is page 112. I mean, I've shown them you before, and that is what ultimately led him to conclude that in paragraph 171 of the judgment, that Mr. Stava had no legal right, no legal right of control, as well as having no proprietary interest in the shares.
So, sorry, just to go back to what you were saying, you say, do you, that if it is right to look at the factual circumstances, putting this quite simply, if one of the factual circumstances is that he could, if he had wanted to, make certain things happen, the other factual circumstance is that he didn't want to.
Yes.
That's
a very elegant way of putting it. Yeah, and we say it's a purely hypothetical, and which is kind of Lord Justice Popplewell's point, that you may have a right to enforce this agreement, but for tax reasons you may decide not to do so. For example, you may, or for commercial reasons, whatever. Until you actually call upon that friend to transfer you the right of control, you don't have it. And you may never have it, because you may never ask for it to happen. And I mean, and in this particular instance, it certainly wasn't never done before the 22nd of December 2017. It somehow occurred to Mr. Stava, or to someone advising him, that it might be a good idea to do it between the two trials. And so he did it, I think, on the 22nd of May 2024, and just as we were preparing our arguments. But
Put another way, the judge would have had to have made a finding of fact, which he didn't, that it would have occurred.
yes, yes. And I don't think he was asked to, because it would have been difficult for my learned friend to ask for that finding, that it was something that not only could happen, but would have happened, because it would contradict Mr. Stava's own evidence about the reasons why he put the shares into the trust as at midnight on the 31st of December 2011. That leads me, if I may, to my supplemental skeleton argument, which I'd just like to run through quickly, which answers all these respondents' notice points that were taken quite briefly by Mr. Richards. And this is in CB 21, CB tab 21, page 1. And this is dated the 16th of January, following the respondent's notice, which was served in mid-December, I think. If we could go over the page, what we do in section B is we have 5 numbered sections, B1, B2, B3, and 4 and 5, and each of those corresponds with one of the points in the respondent's notice. So we didn't use the same letters, perhaps we should have done. So, but B1 is respondent's notice point A, B2 is respondent's notice point B, and so on. And the first point we addressed is the one we've just been discussing, the 22nd of May deed of appointment. And the first point we make is that this never happened, not only not before the end of 2011, but it didn't happen before the date when the arbitration was commenced. It appears to have happened on the 22nd of May 2024. And at that point in time, the point is we don't know what Mr. Stava's succession planning thoughts were at that point in time. And he did at the trial tell us that when I asked him about tax, he said, well, that doesn't bother me because I don't pay tax anywhere. But he did agree with me that he was very well aware of the mandatory heirship rules under Liechtenstein and Swiss law. And I've got a reference to that in this skeleton, which I'll come to in a moment, I hope. If I could just draw to your attention, first of all, paragraph 3, which I briefly referred to in opening, which explains why the judge fixed on the date that he did, the 31st of December 2011. And there are all the references there. And if we could go over the page, paragraph 4 describes the circumstances in which this deed appointment was put in. Paragraph 5 explains that there was no evidence about the circumstances leading to it, which is rather complements the point that Justice Popplewell was made about there being no evidence as to why he didn't exercise the right earlier. There's no evidence about that. And then paragraph 6, it's pertinent to note what the 22nd of May appointment deed does and does not do. It does not, without more, transfer the Diag shares out of the Carilla Trust into Mr. Stava's personal ownership. What the operative clauses of the resolution appear to do is make Mr. Stava the sole beneficiary within the continuing framework of the Carilla Trust and provide for future distribution and transfer of the shares to Mr. Stava upon his notification and instruction. And it's revocable. That's clause 6.3. So it does rather look like an artifice that was designed to be deployed at the second commercial court trial. And then if we go on, paragraph 7, we make a number of points, no background evidence, shorn of any context, no notes about how it came into existence. We don't know whether it's been revoked or qualified. And in the absence, and this is E, in the absence of any evidence, is ever in fact acted upon to place the Diag shares into Mr. Starver's name, meant that the judge proceeded correctly on the basis that no weight could be placed upon it at all.
You will have heard the bell tolling, Mr. Dunning. Tolling for you. You need to finish on
15
time.
minutes.
Yes,
Yes.
yes, you do have another 15 minutes.
So, so my lord, this addresses this argument and this point, and the point I've been making this afternoon about succession planning appears in paragraph 8, and then if we go over the page. I'm sorry. If we go back, sorry, can we go back to paragraph 9? Yes, this is the discussion that took place at the trial, where the judge observed that couldn't really draw any inferences from this document. And then over the page at page 10. We conclude. Now, while we're here, can I just take you briefly then through the other parts of this? The second point, which you just see appearing at the bottom of that page, concerns a new case about a group of nationals, including the daughters. Well, this is a point that wasn't really in play at the trial. We've explained why not. If we could go over the page. We set out the pleadings, no reference, and the pleadings are set out in paragraph 13, 14, 15, and I think possibly 16, if I can see. Yes. No reference at all to this in the pleadings. So there was no reason to explore their nationality or effective nationality at the trial. If we go on, could I just see the full page, please? Thank you. Next page. So yes, this paragraph 17 says, in view of the lack of pleas, no reason to explore this. And then when this was raised with the judge, he wasn't impressed by Mr. Richards pressing this point, and you'll see about 6 lines from the bottom of the page, he says, at the moment, the Swissness in play is the Swissness in play on the pleading, and that did not include the Swissness of the daughters. And if we could then go over the page, make some further observations about this, and explain why this point should not be allowed in. And if we go on again, please. We explain why at paragraph 22, the point that Mr. Richards made today about the fact that the nationality of the daughters was mentioned in passing in the opening, written opening, despite its absence from the pleadings, was not a fair indication that this point was going to be run at the trial. And that argument is developed in paragraph 22. And over the page, please. So paragraph 23, we conclude, there was and remains no case on the pleadings that Mr. Starver and others could collectively be regarded as demonstrating Swiss control, and it's far too late for the respondents to try to advance the argument now. For the reasons set out above, the judge was correct not to rely upon it in his judgment. Then the next section deals with the point C in the respondent's notice, the ability of Mr. Stava to replace the trustee with himself and or a Liechtenstein company under his control. I'm not going to read all of this out, but it
That's the point we've just been on.
exactly one of the main points
He
is
didn't and he wouldn't.
he didn't and he wouldn't, exactly, hypothetical, and it wasn't going to happen anyway. And then the next, if we could, that takes up a few pages. If we go to the next heading, which is 4, yes, it sets out all the things that would have to happen there. And then we come to the legal right of Mr. Stava to exercise the voting rights attached to Diag's shares. And this is the point that I think is still being pressed, though was a bit confused with Mr. Richards this morning when he was equating this with the point about the daughters at one point. But they contend that he had a legal right of control in relation to the voting of the shares. And we say at 38 that this point is unsustainable because the judge rejected a late and unpleaded attempt by the respondent in oral closings to argue because Mr. Stava had possession of the bearer shares in Diag, he could be regarded as the owner of them. And it's contrary to the Liechtenstein law experts' agree position that Mr. Stava was acting as an agent of or custodian for the Corona Trust when holding and voting the shares. And in addition, the judge recorded the common ground that, between the experts, which we set out in paragraph 39. If we go over the page, we explain why, therefore, in paragraph 40, why the judge in the annex concluded that the person in possession of the bearer share certificates in Diag started January 2012, Mr. Stava had the legal right to exercise the voting rights which attached those shares what he believed to be the best interest of the trust, and that this was not a power held in his own right or exercisable by reference to his own interests. He accepted the expert evidence, which he said was ample factual evidence to support that conclusion, and therefore this is not a legal right which demonstrates that Mr. Stava controlled Diag in the context of the admitted agency relationships. So this is the pure agency point does run here. And go over the page. We then come to the final point, and this is a point that at the different stages in his arguments, my learned friend has woven into his case, albeit not by reference to the legal principle, but by reference to the facts which are considered. So if we could have the full page, please. Relevant paragraph. He hasn't actually developed the legal argument based on this from 42 to 44, but the factual point he has made, if you go on, please. Yes, we're starting at 46. Even if the point were otherwise open, the point is a bad one on the evidence. The judge did not find that Mr. Stava's decision to settle the shares of Diag into the Corona Trust was for the purpose of facilitating settlement of the dispute between the Czech Republic and Respondents, nor could he have done on the evidence. Placing of the shares into the Corona Trust at Mr. Stava's own volition is the key event which deprived the tribunal of jurisdiction in respect of Diag. To suggest otherwise is inconsistent with Mr. Stava's repeated evidence and Respondent's own case, namely that the Corona Trust was a valid and effective trust established principle for succession planning purposes and even for the subsidiary asset protection purposes. And it gives you the references to that. Now, Mr. Stava at one point in his evidence did seem to start to say this. And if we go over the page, this is the interchange which then followed. Mr. Stava says the setup was at the request of Deutsche Bank and the Ministry of Finance. And I said, sorry, this is complete nonsense, Mr. Stava, that the Ministry of Finance instructed you or requested you to set up a trust in these terms. So I wasn't disputing it in relation to the sale aspect, but on the trust aspect. This is new evidence and it's completely untrue. It's not as you say, he says. And then I said, in your witness statements, you told us it was done for succession planning purposes, 4 times in 4 different witness statements, you mentioned 2 other purposes, hostile third parties and the Czech state. You never said the trust was set up at the request of the minister. No, I didn't say that the trust was set up at the request of the Ministry of Finance. No. Okay. The trust was set up for my own protection at my lawyer's advice. So this is a completely false point with respect to Mr. Riches that he sought to deploy at various stages in his argument that in some way the setting up of the trust was something that was done at the instigation of the Czech Republic. And when you look at, then if I could ask you to do so, at the judgment, the judgment reflects this. Sorry, the annex reflects this. So if we could go to CB tab 23, page 99. Having made the findings about the discussions with the minister, the next sentence in paragraph 20 reads, by contrast, there is no dispute that the Corona Trust created a valid trust, which was intended to and did take effect in accordance with its terms and the applicable principles. And then he talks about the reasons why it was set up. Now, the point is, it's by contrast. So he's made a finding, what Mr. Goodman characterised in paragraph 19 of the annex, that there was a performative element of the law book transaction. But what the judge is not saying is that there is anything agreed with the minister or performative about the establishment of the Corona Trust and the putting of the shares into the Corona Trust. That was not, it was not a finding of his that there was anything performative about that. And I think, my lord, I just want to close on one point. I've as far as I've been able to, I've followed Mr. Rich's summary at the end, where he said there were legal rights and powers which could be exercised to give him factual control. And that's essentially his position as protector, 22.1 and 22.2. Those are the only actual powers in those two. Settlor doesn't matter, beneficiary doesn't matter. Protector, he just had the powers in 22.1 and 22.2. And the point is he didn't exercise those powers in the relevant time frame, and there were good reasons why he did not exercise those powers in order to take back control. Secondly, we have the rights that he had on behalf of others, the bearer shares, authorization to vote, and running the company. And that was all done qua agent or manager, and comes therefore within the reasoning in Gramercy, which I showed you this afternoon. There is then what my learned friend referred to as the accumulation of factors. Now, it's all very well to accumulate legally relevant factors, but before you do that exercise, I would urge the court to examine each factor individually, nevertheless, to see whether it is a legally relevant factor, because you can't accumulate irrelevant points and thereby come to a legally relevant conclusion. So each point has to be examined individually to see whether it is legally relevant to the question of control under Article 11C. And that applies in particular to all these points about decisive direction of the company, his experience, his past history, his know-how. None of those points indicate that he was, in fact, in control. There can be very knowledgeable agents, there can be very knowledgeable CEOs. In fact, most shareholders appoint their CEOs and their board on the basis that they will bring value and they will add to the company and make it prosperous. But that doesn't alter the legal relationship and the fact that the control rests with the company, which is represented by its shareholders in general meeting. So unless I can assist you further, unless there's anything from behind, I'm sorry to turn my back on you, my lord.
Thank you very much.
My lord, if I may, just 10 seconds on just a reference to the amended particulars of our defence to which you were taken, just the paragraph where we raised the section 73 point on the APOC 4 is paragraph 3, just that, because it may have not been clear otherwise that we had raised the section 73 point. Apologies.
Thank you. Well, we will reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors whose details have been provided to my clerk. But it would also be helpful, please, to have a list of how counsel would like to be referred to. We have misters and we have doctors. I don't think we have professors, but for all we know, I may. So if you could tell us, please, how you would like to be referred to in the event that we do need to name check you in the judgment, that would be very helpful. And it is very good, in fact, that over the course of the week we've been addressed by as many as 6 counsel. That's very much to be encouraged. Change of voice is very welcome. Once you've got the drafts, that is so that you can draw our attention to any typographical or minor factual errors, and we hope that you will be able to agree a draft order in the light of whatever we decide. If you can't, then we will have short written submissions so that the judgment or so that an order can be finalised. We'd hope to do that together with hand down. Recognise that this is quite a complicated case potentially, so if it takes longer to agree an order, then we'll simply hand down the judgment and catch up with the order thereafter. As you know, circulation to the parties for any purpose is permitted for the purposes identified in the Counsel General for Wales case. It's the responsibility of the solicitors to ensure that that is the only purpose for which that is given. And again, as you know, if that is used for wider purposes, then that may be a contempt of court. But to finish on a happier note, we're very grateful for all the submissions that we've had and for all the hard work that's been done, both by those who have spoken and the teams which have been supporting them. That concludes the appeal. Thank you very much.